All right, everyone. Again, like I said, my name is Clint Goodman. I'm going to go ahead and get us started, and I'll continue to add people as the stragglers come in. I'm honored to be here with you tonight, and what I've been asked to do is put together a list of questions that several managers for HOAs have asked, including from Vision. So these are, I organized the questions to be the top priority questions that actually lead to the most lawsuits. So I think you'll find tonight's discussion very informative. Whether you are a brand new board member just getting on the board or you're a seasoned board member, my goal is to make sure that everyone learns something good tonight and you walk away having been educated. My plan is to spend about 30 to 45 minutes on these questions and discussion. And then I'll open up the forum to all of you for any questions you may have. As I explained earlier, there's a chat function here. So as I'm talking, if you have any questions, please feel free to send me a question via chat, and I'd be happy to look at that in between each question. I do mute everyone for there's pros and cons to this. Part of the pro is obviously it keeps the background noise to a minimum. There are 75 participants right now, so there's probably a lot of background noise if we didn't have everyone on mute. And the con obviously is you can't just say, hey, I have a question. But that's actually with 75 people, now 77, as I continue to meet people, it's actually be unmanageable if everyone could talk. So having said that, in my courses, what I love to start us with are what I call stupid laws to give us a few laughs before I dive in to the actual presentation. So I'm going to do that for us today. I don't know if there's any Texans out there, but I found this one. There aren't too many stupid laws in Texas, but they come across occasionally. I didn't know this, but in Texas Penal Code, so this is a state law, folks, it says it's illegal to ask about a job. So in other words, if I'm seeking a job, I cannot ask somebody if they're hiring. Specifically, the language says in the statute, Texas Penal Code 38.12a, a person commits an offense if with intent to obtain an economic benefit from the person knowingly institutes a question that solicits employment. So be careful if you're trying to find a job in Texas. All right, so that's the first one. There's another funny one here. Let me get to this. These are just crazy. Random stupid law. It is illegal in several states to pump your own gas. I don't know if that qualifies as a stupid law. Here in Arizona, we all do it. But if you're in Oregon and some of the other states, you cannot pump your own gas. I personally think it's stupid because I like to pump my own gas. But hey, what am I? Here's a good one. This is crazy. Longyearbyen. I think this is Iceland. So we're going to Iceland. It's illegal to die in town. If you live in Longyearbyen, it's illegal to actually expire within city limits. The reason behind this was in 1950, it was discovered the bodies were not decomposing in the permafrost. The town passed an ordinance to outlaw dying to protect residents from disease that may spread from bodies in graveyards. So I guess this is especially helpful with COVID. They really made it, really crack down on dying in town. So anyways, those are two stupid laws to get us started today. All of you, just so you know, a couple of ground rules. One, this is being recorded. So that any board members that haven't attended to that tonight can listen to this. It is very informative information. So if any of your directors on your boards haven't had a chance to participate and you found it worthwhile, reach out to your manager at Vision. I'm sure you'll get a copy or have access to this recording in the future. And secondly, we now have a total of a little over 88 participants with us now. I assume within the next couple of minutes, there'll be over 90. That means that there are multiple boards on tonight. And so when you ask questions, just note that I cannot give legal advice. So tonight is not legal advice because legal advice occurs when it's me and you as a board, not me and everyone. So if you have a question that you want to ask towards the end of the program, or as you're wanting to ask a question in the chat, just know that it is not legal advice. It's general information only for now. And if you want to follow up with me afterwards in private, you're more than welcome to. I'll give you my information if you don't already have it after we're done talking. So having said that, without any further ado, let me get into some of these questions. The very first question that was asked by a manager, and by the way, again, for those of you that are just joining, tonight's training is on question and answer. We took literally dozens of questions that are being asked by managers right now about the current laws, the new laws, some of the new case law, some of the lawsuits that are originating, and we boiled them down into the top 6 most important questions in our minds, leading to either litigation or big questions that are constantly asked. So first question, how many of you are on the board? All of you should raise your hand and say, I am. Now, the next question is, how many of you are on the Architecture Review Committee or Design Review Committee? Just raise your hand. Now, keep your hand up if you chair that Architecture Review Committee. So I chair our Architecture Review Committee because I'm not only an HOA attorney, but I'm on my own board. And I'm on the Architecture Review Committee as well. And they asked me to chair the ARC. So I chair the ARC. Now, here's the question. The question is, does the board liaison to the Architecture Committee have to be present for the committee meetings or not? Do you actually have to be at the meeting as the chair of the ARC? So we know that the statute for planned communities requires that the board have a member chair the ARC. That's ARS 33-1817. What I'm going to do throughout the presentation is I'm actually going to share my screen occasionally because I wanted to go to the actual statutes and show you some of the statutes. So I'm going to see if I can share my screen here real quick. Okay, you should see my screen now. This is my website. My website, you can search any statute by keyword in our public forum. So if I enter 1817 or the keyword, whatever it might be, this is the statute that controls a board chairing the committee. So it says right here, for planned communities, it shall include at least one member of the board of directors who shall serve as chairperson of the committee. Okay, so that's what the statute says. The question becomes, though, right here, do you have to actually be in the meetings themselves? So here's the answer. And there's the link. So the answer basically is that, the answer is, when it comes to chairing, the statute only said you have to chair the committee. It does not say you have to chair each meeting. That's important because occasionally you may be out of town, you may not be available. So it's our opinion that you don't have to actually chair every single meeting. Now, having said, you have to chair the committee as a whole. Having said that, I do my best to be at every Architecture Review Committee meeting. My board, we actually don't have meetings because you don't have to be subject to the open meeting law as a committee. You can approve everything via email on our committee. So that's what we do. It avoids that whole question. So I chair the committee, but if I'm approving via email, it doesn't really matter. So in my opinion, that's the easiest thing to do as an Architecture Review Committee, is to do it via email because it's not regularly scheduled, it's ad hoc. And the statute would require you to do it in front of the members only if you have meetings that are regularly scheduled, okay? So the answer to this is, it's our opinion, you do not need to chair every meeting. But the better approach, in my opinion, is don't necessarily have architecture review committee meetings on a regular basis. Just handle it when they come in, okay? If you do prefer to have regular meetings, to actually approve them on the third Thursday of every month at 7 o'clock, that's when your committee meeting is. You're subject to the open meeting law under that statute I showed you. And in that situation, you should do your best to be there if you are the chair. If you aren't, then substitute in somebody else, with the caveat that we don't have case law on this. I don't think we ever will have case law. So a judge may disagree with what we're saying, but I don't think so. The reason why we don't have case law yet is because it's never really been litigated. So that's the answer to that question. The next question is a really good one, actually. This has to do with marijuana. I think most of you are aware. If you're not, that's okay. But Arizona has passed some recent marijuana laws. Now, this one goes to ARS 36-2852. Now, this revised statute, 36-2852, deals with somebody's ability to grow pot on their property for personal use. So the question is, here's the question from the board member, quote, "Are residents growing marijuana in their backyard? Does the new marijuana law prohibit the board from doing anything about it?" So the answer is, this statute does allow anyone to grow, or it says cultivate by the statute, and you have to be 21 years of age or older, okay? So if you're dealing with a minor, and no, they can't cultivate weed. But if you're at least 21 years of age, you can cultivate not more than 6 marijuana plants for personal use at your primary residence. So that's in your house. But the statute actually goes on to in a closet, a room, or other enclosed area that is secured by a lock or other security device that prohibits minors from being able to access it and prohibits it from being visible from public view. So technically this would apply if you're in a condominium and you have somebody that's growing 4 or 5 marijuana plants in their condominium unit. If you have this statute could apply then, where the condo can't prohibit that. But if they're growing it on the balcony, that could be a problem, because now it's not necessarily an enclosed area potentially, but it doesn't have a lock or security device that prohibits minors to where it's not visible from public view, arguably. Same thing with a backyard. If they're growing, if you're dealing with like a plant community and somebody's growing this in their backyard, every time I've seen it, it's more than 6 plants. So you can argue it's way beyond personal use. And again, if you can show us more than 6 plants, the statute doesn't protect it regardless. So bottom line, key points to keep in mind is, if this is an issue that's facing you in your boards, you as an association can still prohibit the growing of marijuana in backyards or in units if it exceeds 6 or more plants, and if it's outside of a closet, room, or other enclosed area. Now, admittedly, the statute doesn't define whether enclosed area can be a backyard enclosed by a privacy wall, but the statute also says a lock or security device has to lock it all up. So that to me tells me that it has to be an enclosed area, like a greenhouse area, if it isn't a backyard, that you can't walk into. And I think most legislators would agree with me on that. Until we have case law, maybe a judge could argue the other way and find the other way, but I doubt it. I think the industry standard right now is this is for closets, rooms, and if it's in a backyard, an enclosed locked area that cannot be accessed by any way by minors. Okay, so yes, we actually have stopped the cultivating of weed in both condominiums and planned communities and have educated other attorneys on this topic as well when they try to throw that statute out. Very good. All righty. So the next question that I have is dealing with quorum. Our bylaws do not say anything about quorum. So they don't know what quorum is for the members to meet and vote. They don't know what quorum is for a board to get together and vote. So what they did is they turned to the nonprofit corporation statute. So a little bit of background for association boards. There are three main statutes that apply in Arizona. Two of them apply to you in your community. There's the Condominium Act, the Planned Community Act, and then the nonprofit corporation statutes. Okay? So if you're a condo, the Condo Act and the nonprofit corporation statute would apply. If you're a planned community, the planned community and the nonprofit would apply. Okay? So under the Condominium Act, it actually has, well, let's start from the baseline. The nonprofit corporation statute does have a quorum requirement. It says, in the absence of something in your bylaws or articles, the quorum requirement is 10% of the members. Pretty low. So if you have a community of 100 members, it's 10%. I would imagine that 90% of you already have quorum requirements in your bylaws, so you're not worried about this statute, but the Nonprofit Corporation Act fills parts where the bylaws or articles don't address it. So that's number one, 10%. But here's where people get hung up. If you are a condominium, the Nonprofit Corporation Act is trumped by the Condo Act, and under the Condo Act is 25%. And that statute is ARS 33-1249. Okay, so 1249 is the condo statute that says if you're a condominium, your quorum is 25%. If you're a planned community or whatnot, your quorum and your governing documents are silent, it's 10%. But here's where the rub is. A lot of times board members go, oh, okay, what's our quorum requirement? So they go to the bylaws. They don't see anything in the bylaws. Then they immediately jump to the statute. Before you do that, though, before you jump to the statute, first go to the articles. See what the articles say. This is where people get in trouble. See what the articles say first, and then see what your CC&Rs say before you go to the statute. Because in all cases, the statute takes a sidestep. It sidesteps to what your documents say. All right, so don't just stop at the bylaws. And if there's a conflict, this is really important. If there is a conflict between your articles and the bylaws, which one applies? The articles. So there's a hierarchy here. The hierarchy, real quick, is the plat. And then after the plat, it's your CC&Rs. Then after the CC&Rs, it's your articles. Then after the articles, it's your bylaws. Then after bylaws, it's your rules. Just think of that as a totem pole. And at any time, if there's a conflict, you always defer to the one that's higher. The most recent scenario I saw where there was an issue was the board had an election to their annual meeting with the election. There were a couple of seats up for election. It was a 5-member board. There were 3 seats that were up. They looked at the bylaws, and the bylaw quorum said 10%. Similar to the Nonprofit Corporation Act. It's like, okay, cool. Yada, yada, yada. They went along. They went through, they only got like 15% quorum. So they thought they had quorum. Well, after the vote, an individual that was not elected, who was on the board before, it was not elected, re-elected, said, hey guys, guess what? You screwed up. This election was null and void because our articles of incorporation say our quorum requirement is 20% and we only hit 15. Yeah, our bylaws say 10, but our articles say 20. So who's right? He was right. So they had to redo it. And if they didn't hit quorum, this is interesting too. If you don't hit quorum, you then the then existing board members continue on the board until their successor is elected. So this is like me right now. I'm on my board. I was elected 3 years ago. No, I had a 2-year term. I was elected 3 years ago. Last year, we did not get quorum. And so I'm an interim director until our next annual meeting. And I'm going to show you the statute here. This is a really important one for you to keep in mind because this question comes up all the time too. Let me share my screen and come back here to the statute. So the nice thing is you can search by keyword. I'm going to go nonprofit corporation. I'm going to put in director terms. And this is going to pull up all the statutes dealing with director terms. Terms of directors, generally. If I click on this one, I think it's this one in the Condo Act. You can see right here, 10-3805, subsection E. Despite the expiration of a director's term, a director shall continue to hold office until the director's successor is elected, designated or appointed, and qualifies until the director's resignation or removal. Okay? So I'm an interim director right now serving on my board, even though I wasn't technically elected at our last meeting. Why? Because we didn't hit quorum. All right, there's a couple of questions, so let me take a look at the chat. So the question is, can I please explain how boards trying to vote a member off? Sure, I can do that, since we're on the topic of boards. There are two main ways that a board member, well, three. There are three main ways that a board member can be removed from the board. One of them is by a judge. Another one is by the members, and the other one is because they're just disqualified to sit on the board anymore. Now, let me go over each of those. The statute allows a judge to remove me as a board member if I steal money from my association or commit a fraud on my association. If that happens, the board can sue me as a rogue director and ask the judge under the statute to remove me. And the judge has authority to do that per the statute. But that's really it. If I'm stealing money or committing a fraud on the association. So that's what a judge can. The next one is when the members can. Under the statutes for both condos and planned communities, if you get a petition to remove the board that's signed by about 25% of the members, at least 25% of the members, if you're a community of less than 1,000 homes, it's 25%. If you're over 1,000, it's 10%. But anywho, if you receive a petition signed by members that meets the threshold, you have to call and hold a removal meeting to vote on whether or not the board members subject to the petition are to be removed. And so when I get that, if I'm a member voting, it's going to say, do you want to remove Clint Goodman, yes or no? And I check mark the box, sign it, and send it back if it's a paper ballot. If it's not a paper ballot, electronic vote, I do that same thing via electronic means. Okay? That's how, and if members, simple majority of the members do it, then you're off the board. The third one is a little more confusing. The third one is called disqualification. So let's start with the easiest example. In my community, you have to be a member to be on the board. And a member is an owner. So it's not like my neighbor across the street in another community can get elected to our board, right? They want to have people that own in the community be on the board. What happens the moment I sell my property and move away? I'm off the board, right? And most of you have that same provision that you have to be a member to be on the board. So you're disqualified from being on the board, and a vacancy automatically occurs, all right? And then the remaining board members, usually based on what your bylaws probably say, appoint somebody to fill that vacancy for the remaining term or until the next annual meeting, whatever your bylaws or articles say. That's how that works for disqualification. The deeper question now, the level 400 question, not the level 101 question, but the level 400 question now is, can we disqualify a board member who's on the board if they violate some sort of code of conduct? So they're disclosing corporate records, they're disclosing violation reports, delinquency reports, all the executive information, they're disclosing it. A, is that a problem? Yes. You can't disclose executive information without approval from the board. So yes, absolutely, a judge could order you, don't do that, stop it. But the question is, can the remaining board just say, hey, you're off the board? This kind of happened in a case called McNally v. Sun Lakes. It's a case from about 4 years ago. And in McNally, she was disclosing executive information to the membership in the interest of transparency, as she put it. And the board basically kicked her off. She sued, and the Court of Appeals, it went all the way to the Court of Appeals, and the court was very sympathetic to the board, but the place they turned to were the articles and the bylaws. And neither the articles or the bylaws gave the board the express authority to kick her off. In fact, it said that they were obligated to be at meetings and they couldn't miss 3 meetings. So the court said, look, absent express authority in your bylaws or articles, a board cannot kick off another board member. So since that case, we've got communities that are amending their bylaws and amending their articles to incorporate a code of conduct. So if there is a rogue director, the board can get together and disqualify someone. So if you don't have that language in bylaws or articles, you can't do it under the McNally analysis. And so if you do want to look into incorporating codes of conduct into your bylaws or articles, it's very important that you talk to your attorney, because I'm not going to get into the weeds on this. I'm going to move on to the next topic in just a minute. But it's really important to talk to your attorney, because the state of the law on how to end up removing people from a board and disqualifying them is disputed. We don't have case law yet on this specific issue. All we have is McNally, and McNally wasn't directly on point to some of this. So there are arguments that you want to get legal advice on, okay? So just consult with your attorney if this is something that you want to do, and rely on her advice, okay? Or his advice, whoever it is. Very good. Now, let's go back. I don't think I'm sharing my screen anymore, but that's okay. Next question. Let's go back to the Architecture Review Committee. This is there's so many issues coming up right now. When we get an application to approve or deny, and when we deny, what happens when we send that back to the homeowner? Sometimes they say, no, I need it approved. Other times they resubmit because we tell them, hey, as submitted, this isn't going to be approved, but take a look at the setback issues and then resubmit. They do, and it's no problem. But there are some people that say, hey, you cannot deny it. That's unreasonable. So here's the question that we got asked. What are the standards for boards and architecture review committees when approving or denying, just basically considering these applications, okay? Here's the good news for you. There's good news and there's bad news. The good news is there's a case directly on point for us. It's called the Tierra Rancho Kitchikoff case. And in this case, what happened was an individual wanted to do some modifications to their lot in their community, submitted their application for review and approval. It was turned down and they went ahead and did it anyways. And then they got sued. Hence why we got a case, right? Tierra Rancho v. Kitchikoff. Kitchikoff's argument was, hey, you can't just turn me down. That's unreasonable. And the board's argument was, we turned you down because the rules prohibit what you did. Here's the rules right here. So at the trial court level, the HOA smoked the homeowner, just smoked him. They won on a motion. And then Mr. Kitchikov appealed to the Court of Appeals. And in the argument, Mr. Kitchikov argued that this really should go in front of a jury. You can't win on a motion because a jury has to decide if the board or the ARC acted reasonably. So this is the question. And so what the Court of Appeals did is they didn't make a decision on who is right and wrong, but they incorporated Arizona law now for us to consider when we review these applications. Obviously, if it conflicts with an express provision. So if I get an application on my ARC that says, hey, I want to build a 2-story home, and our CC&Rs prohibit 2-story homes, it's getting denied because it's very clear. It's when it isn't so clear, that's where we're talking about this subjective area. So one, the Court of Appeals held that the design review committee, architecture review committee, board, whatever you want to call yourselves, whoever's reviewing the application, they have to act reasonably in their discretionary powers. This goes for boards, committees, anything, okay? And then it went on to say, what does that even mean? There are 3 main factors, excuse me, that you want to keep in the front of your mind as you're reviewing this. They are visibility, uniqueness of the property, and the impact on your community that approval or denial will have. So those 3 main factors are the 3 main factors the Court of Appeals put into Arizona law now as our case law. So in determining whether you're acting reasonably, you have to consider the impact, the visibility, and the uniqueness of the property. So are we talking about something that no one's ever going to see on a corner lot at the edge of a cul-de-sac, and they're trying to put something in there, the very far back of their corner that's completely shielded? Or are we talking about something that's in the front yard of a home that's in the main entryway? There's visibility, impact, uniqueness of property issues. So those are things you'll need to consider. Most of the time, if you've got express rules and it's in writing, I'm going to say that's okay. You approve or deny based on whatever's in your documents actually written down. But sometimes you run across those scenarios where there aren't things that are written down. And occasionally a judge will ultimately rule that what is written down is unreasonable. So there is that. But at the end of the day, that's why you want to make sure that every 5 to 10 years or so, you want to have your counsel review your rules to make sure that they're still tracking with the industry standards. They're still okay within the case law that's been ruled on for the last decade. So very interesting case that applies now not only for architecture review committees, but this Kitchikov case applies to everything a board does. Everything from enforcement to the collections to anything and everything. The standard is you need to act reasonably, and the judges will almost deem that per se reasonable on your part if you rely on your experts, including attorneys. But when you're in that scenario where you're dealing with somebody's property and what they're doing to it, you consider those 3 factors. Very important to keep in mind. Okay, very good. Let's go on now to short-term rentals. Can I just see a raise of hands to how many of you have concerns about short-term rentals in communities right now? I think I'm seeing of people that 50% of you raised your hand. So I would imagine that several other people have other concerns. This is another hot potato topic, okay? So the question really is, how do we prohibit short-term rentals? I just reviewed a fine policy today that a board wants to adopt. They want to assess $5,000 for the first violation, $7,500 for the second violation, and $10,000 in fines for the third violation, because their CC&Rs prohibit short-term rentals or anything less than 30 days. Is that reasonable? Let's go back to that Kitchikoff case. Is a $10,000 fine reasonable if you're caught renting your property? Some people say no, but here's the perfect example. In this community, I'm going to say yes, because the median home average in this particular community is $10 to $15 million. There are some $30 million homes. There are some $5 million homes. But so like a $25 fine in that community, it's like, okay. So in that community, yeah, I think that could be reasonable. In a community where the average home value is 200 to 300,000 and the home median for annual revenue is in the 100 to 150,000, $10,000 fine is most likely not reasonable. I don't think that's a good idea. I think there are other alternatives. But let's talk about short-term rentals. Number one, very important. If your CC&Rs do not prohibit short-term rentals, you can't do it. So I'm going to share my screen again and go directly into the statute for you. This applies in both condos and planned communities. For condominiums, it's 1260.01. And for planned communities, it's 1806.01. But right here, this gives the unit owner express authority to use the rental property however they want, unless prohibited in the declaration. Okay, so that the CC&Rs, i.e. declaration, have to prohibit rentals. And then when it comes to the time period, the declaration, not rules, but the declaration has to have the rental time period restriction. Okay, so if you're in a community where you've got rental restrictions and it's in your CC&Rs and it says at least not less than 30 days, you can prohibit short-term rentals. If it doesn't say that, most of you are going to need to amend your CC&Rs to incorporate that. And again, talk to your attorney. Because in planned communities, you can amend away, no problem. If you amend your CC&Rs to prohibit time restrictions or Airbnb, that kind of thing, most likely no one's going to really challenge the amendment. In condominiums, some people think that you have to have unanimous consent. Under this, they argue, in fact, we're dealing with a case right now where anti-HOA attorney is suing one of our clients for doing an amendment in a condominium that prohibits short-term rentals, but they didn't get unanimous consent. And he's arguing the Condo Act requires unanimous consent. And we are the insurance defense counsel for that board that was hired by the insurance company to defend the board. And we think that the law is pretty settled in Arizona that you don't need unanimous consent, even in condos, but we don't have the case law yet. So until we get the case law for condominiums, you just have to know if you're going to amend your CC&Rs in your condo, there's going to be people that argue with unanimous consent. The good news is for planned communities, we've got case law now that says it's not unanimous consent. So it's going to be, hopefully, in our opinion, pretty easy to argue it's not unanimous consent for condos because it's not unanimous consent for planned communities. But just know there is that issue. Now, the next question. Once you have this in your documents. Oh, by the way, with condos, once it's recorded, even if you don't get unanimous consent, keep your fingers crossed nobody sues you for a year, because you only have a year to sue over this stuff once the CC&Rs are recorded. After that, they're for condominiums even, you're good to go. The statute only gives somebody that wants to challenge it 1 year to do it. It's not even a statute of limitations. It's called the statute of repose, which is stronger. So anyways, how do you actually enforce short-term rentals. How do you resolve it? Well, you can get an injunction against the individual, a court order ordering them to stop doing it. Some people don't want to go to a judge and do that process because it costs a lot of money. I think we're of the last maybe 20 or so of these cases, we've got it settled out. If they hire an attorney within the first month and they agree to reimburse the association fees because the attorneys realize that it's good, and their client needs to settle it. But some people, they like to fight, and you might end up spending a lot of money trying to enforce this and getting an injunction against a homeowner. So it's important for you to talk to your attorney about your options. Couple of things we like to do. We like to adopt resolutions that require them to prepare and provide you with all the tenant information every time they enter into a landlord-tenant relationship. The statute, that same statute that I showed you, clearly allows that under 1260.01 and 1806.01. So that's kind of a pain in the butt for them. Some cities do have authority to punish them if they're in a area that's zoned to prohibit short-term rentals. Admittedly, the legislature took that away from cities, then they gave it back. Now there's a bill pending right now to take it away again. So who knows what the cities can ultimately do with short-term rentals. But at least for us, if it's in your declaration, go for it. I have no problem with you prohibiting it. Some of you may wonder, how in the world do you even find these people? We've developed a rental monitoring program. So if you want to take a look at our rental monitoring program options, you can email me offline and I can send that over to you. So in any event, it's important to many people to limit or eliminate short-term rentals. Some boards love them because they're in an area where it's acceptable and encouraged, but I see most boards having a problem with them. So there you have it. That was basically my last question that I was going to cover. Oh, there's a COVID question. How many of you are concerned about COVID in your communities? If I ask this question, a few of you are, but if I ask this question, let's say a year ago, every one of you would have went and raised your hand. So let's talk about this in conclusion tonight. The question is, we love holding community events, but are worried about being sued over COVID. What's the HOA's liability, if any? So in preparation for tonight, I called one of my attorney friends, Triumph Curio. And I don't know if you've seen his billboards, but he's got tons of billboards downtown Phoenix. It says Triumph on it. He's a PI attorney and really good friend of mine. He's my next door neighbor. We do a lot together. I asked him, I'm like, okay, Triumph, let's say you have a very wealthy individual in a community, an HOA, that dies because of COVID, and the husband of the deceased wife sends a demand letter or comes and talks to you and says, I want to sue the HOA because my wife or my husband, whoever it was, caught COVID at a community gathering, a hot dog gathering or pool night or whatever community event you had, okay? What do you think Triumph told me when I asked him if he'd take that case? I've got all of you on mute, but I see some heads shaking like, no, he wouldn't even touch it. You're right. Like, I wouldn't touch that with a 10-foot pole for a couple of reasons. And then I asked him, all right, well, you're not going to touch it. Do you know any of your PI friends that would? And he said, well, there is one guy out in Phoenix that claims he'll take these cases and sue HOAs, but he's a bit of a circus. I'll leave out the expletives to keep it G-rated, but that attorney isn't really very respected in the community of PI attorneys. And here's why. First of all, these are negligence claims. In order to prove negligence, you have to prove that there's a duty that's owed to someone. In this case, a duty by the HOA is owed to anyone on its property. And the answer to that is actually yes, there is a duty. And that's a case called Martinez v. Woodmar 4. You owe a duty to protect everybody on your property from foreseeable harm. That's your duty, to protect from foreseeable harm. The next thing that they have to prove is that you breached that duty. So did you provide proper COVID protocols, things like that? And that might be easy to prove, who knows? It's a big question mark. But the third element is the toughest. And this is why Triumph says, hell no. Causation. You have to prove, if you're the PI attorney, that the breach of duty caused the damage. And the damage here would be death. It's literally impossible to prove causation because you have to establish there was never any contact with anyone else. I mean, if husband died, did wife go out and get gas, go out and get groceries? Did she bring it back with her? I mean, there's a whole list of endless possibilities when it comes to how one gets COVID. And this is why, in closing, Governor Ducey signed into law an actual bill or a law that prohibits people from suing businesses for COVID, which includes nonprofit corporations, by the way. Basically, what that law says, it says that if anyone wants to try to sue a business for COVID or over COVID, you have to prove by clear and convincing evidence that the association failed to act in a willful, grossly negligent manner. Grossly negligent, good luck. So now, as we're hopefully ending the pandemic, near the ending of this pandemic, our concerns about COVID and liability are much less for several reasons, including what Governor Ducey had signed into law. I am not concerned about community gatherings anymore. I think that you can do it. If you are in a community that is more high risk, you might want to consult with your attorney about some things you can do to help limit the spread. Who knows what the science tells us now? You hear everything from the left, the right, I don't know. But the bottom line is, if you're in a high risk area and there's a spike or whatever, you might want to consider not doing it. But if you're in a community and you as a board love community gatherings, like this particular community that submitted that question to us, they love to do it in their open parks, and they all get together and absolutely knock yourself out. Because I think it doesn't matter if you're left or right prone. Most people, including the CDC now, agrees that open airspace transmission is much, much harder in open airspace. Now, big caveat, I'm not a doctor. I'm not an expert in that subject matter, so I can't tell you whether you get COVID in open airspace gatherings, but from a legal standpoint, I can tell you, you're not going to be grossly negligent having a gathering in open airspace. Will you be grossly negligent having a gathering in enclosed in a clubhouse? The answer that I almost always say is no, unless you know one of you has COVID and you actually know they're going to attend and you encourage them to attend. That's kind of where you get to potentially an issue is, I test positive, guys. Okay, we'll see you tonight at the event. That could be a problem. I mean, my brother-in-law had this problem. In conclusion, he has a company. I'm not going to name the company that he's got out of Yuma, but they had a gathering a year ago. He invited his father-in-law, who he knew had COVID. His father-in-law came to the gathering, and it was a business meeting. His father-in-law was coughing and joking about COVID in the meeting. 2 weeks later, one of the employees at that meeting got COVID. And 2 weeks after that, his wife died. So I think, I mean, you can't prove that he got COVID at that meeting, but that to me is gross negligence. I'm sorry. My brother-in-law was clearly wrong. I don't want that on my conscience. So when it comes to COVID, I would just say if you absolutely know somebody has it and they're joking about it, I wouldn't encourage them to attend in that scenario. That's probably the only one that I'd actually say to steer away from. Okay. So, hey, I had a great time tonight. I hope you all learned something tonight. And I look forward to seeing you all again. If you need to reach out to me personally, let me share a couple things here on my screen. Here's my website. Let me close this a little bit. Here's my information here. Our phone numbers here. It's really easy to remember, goodlaw.legal. If you need us, you can fill this out or call us. If you click on this bar, there's tons of resources here. There's the statute search. There's courses that we offer for our managers, and they're helpful for you as well. They're actually CAI approved courses. There are podcasts that we have. These podcasts are great. I've interviewed anyone from people that have, well, you got to log in actually to have them, but the podcasts in here include me interviewing special agents with the FBI on security issues. They include me interviewing the people that drafted up the group home care facility laws. If you've got group home care facility issues, I've interviewed judges about attorney fees and what they think about HOA cases. Lots of really good information in there. And then I've got articles here, obviously, too. So check it out if you ever want to. I've got a board member portal for you. If you click on subscribe, it's free, and you'll be able to go right into your board member portal and access all this stuff. Statute search is in the public domain. But if you need me, you know where to find me. Just go to goodlaw.legal or email your manager, and they have all my information. I'm more than happy to stay on. I guess if you want to hop off, go ahead. But let me just make sure that there aren't any additional questions that we've got as we conclude today. Joe Naylor, I'm not going to recite what you said. If you want to see his comment, I agree 100%. That's pretty political, though, so I'm not going to comment out loud on that. Yeah. Last one, Scott Freestone said, if an HOA board is meeting over Zoom, are all members required to have their camera on to establish a quorum and validate the person? Ooh, very good. I like that question. Because you're worried whether it's a spouse or a business partner. It's a great question. You're the first person that's asked that question from me. We don't have, number one, we don't have case law on it because it's such a new question. But if you think about it, up until COVID happened, when you would be meeting in person, or people call in, you could hear them, you could you know it's their voice. So my thought is treat it just like the telephone call when you have board members calling in on the phone. If you don't recognize, I'd say 99% of the time, one of you would be able to recognize the voice of who's on the line. Now, are we going to be able to get them to stop or prohibit them from turning on the speaker and having their spouse or somebody else hear who it is? No, probably not. As a board member, everyone has a duty to keep the executive stuff executive. But if you don't recognize the voice, if they refuse to identify themselves, then yeah, I don't see why you have to proceed and allow them to attend if you can't verify the identity. If you can verify the identity without the camera on, I'd say proceed forward as you normally would. But if it's a real concern to you, I'd say reach out to the attorney to make sure you're good with that and get something in writing. But I don't see a reason why you can't verify identity. I think it's important for you to verify the identity. As far as the question about my portal, what email do you use to log in? You got to subscribe first, and you enter your email and whatever password you want, then you use your email and your password. What do I do when HOA homeowners do not vote on an amendment and refuse to vote, and you need 75% to pass. What do? Well, in my community, we recently amended the bylaws, and our bylaws actually required 75% of everyone, which was crazy, right? So several of us got together and we reached out to, we each divided and conquered. We reached out, we didn't tell them how to vote, but we encouraged everyone, please, please, please vote. We didn't take the vote and turn it in ourselves, but we just encouraged everyone to vote. And that got us to the 75%. Because if you throw out a request for an amendment and you just don't do anything, I've never seen those pass. You have to have a grassroots campaign. Just make sure that you don't do anything that could accuse you of ballot harvesting, i.e. checking yes, and then showing up, having them sign, putting it in the envelope and turning it in yourself. An anti-HOA attorney recently sued a board over that, and it was settled out. They didn't go to court on it, but they settled the case, and they agreed to do a do-over. Both sides thought they'd save a lot of time and money just doing it over. But they had some pretty good arguments. The more involved you get in helping somebody complete a ballot, the closer you get to ballot harvesting. But I have no problem with you going out and encouraging people to vote and expressing your opinion. That's fine, but you just have to make sure that it's your opinion and they know it's your opinion, and encourage them to go to a meeting to hear the other side as well, where there's a forum for both sides of the issue. All right. Well, I enjoyed our meeting today, and hopefully I'm invited back. And when I am, we'll go over some more of this stuff. So have a wonderful evening, everybody. Take care. Bye-bye.